Okay, if we could move on to re-examination, Mr. Cosgrove.
Mr. Johnson, just a few matters to pick up on. First of all, just a couple of general points. You were asked throughout the cross-examination quite a lot of questions about the previous inspector's decision at NID 3.8, Inspector Bristow, and some questions in particular about how you'd weigh that in the balance. First question, when you see the appellant's evidence and as you read it, Mr. Collins' evidence of balance, to what extent do you understand he's weighed that inspector's decision in his balance at all?
Well, I've given that decision significant weight. I don't believe Mr. Collins has given it any weight.
Now, you say you've given it significant weight. To what extent is your judgment that you give to the inspector on various matters that you've covered in your evidence reliant on that previous inspector's decision, or is it dependent on your own planning judgment?
It's entirely dependent. Well, it's mainly dependent on my own planning judgment. I have taken that into account. It's my judgment I've formed through my proof of evidence as well.
Yes. All right. Thank you very much. Now, you were asked some general questions about natural beauty, and there were some questions put to you about the proposition that natural beauty can include areas of built development within the natural landscape and this natural landscape. And in your answers, you said, yes, but you need to contextualize that. I just want to understand what you meant by, you said, yes, but you need to contextualize that in relation to this proposal. What did you mean by that?
I think the conversation was along the lines of the designation of the national landscape, and that will, by its nature, include built development. That doesn't per se mean that you can go and develop in the national landscape, because there is existing development in the national landscape. So there's a clear distinction.
Yeah.
Between the two.
To what extent do you consider this site, looking at Mr. Petrio's evidence and your own judgment, currently constitutes an area that is characterised by built development, part of the national landscape?
No, I don't. No, it's an undeveloped site in the countryside, and also represents many of the characteristics of the landscape character assessments produced.
Okay, thank you. Now, you asked a number of points about the NPPF, many of which I can deal with by way of submission, but just take up the copy of the NPPF wherever you may have it. And if you just turn to paragraph 78, please, of that. You asked some questions relating to this particular part of the NPPF. And just a short point, do you have that?
Yes, paragraph 78.
78, and you asked some number of questions, some questions related to C and the propositions put to you that from the 1st of July 2026, certain things will kick in. I can use that colloquial phrase. My question to you is, to what extent do you think it will assist this inspector in your planning judgment as to what might happen in or on the 1st of July 2026 for the purposes of looking at this appeal?
Well, there will still, at that point in time, judging by the LDS, there will still be, the current plan will still be in play. The emerging plan will be far more progressed. One would hope, certainly by that point in time, but the existing adopted local plan will still be the adopted local plan.
All right. Thank you. Keep the NPPF to hand. Now, you were asked various questions about the management plan and the management board. Perhaps we probably don't need to go to the document for the purpose of this question, but you remember you were taken to some of the guidance issued in December about the statutory duty. Just for the inspector's note, that's NID 7.11. That's the guidance on the statutory purposes and so forth. And there were some points in there you were taken to which refers to dialogue with the board and the importance of the management plan. Okay, that was the context of some questions.
Yes.
Now, there are various representations made by persons on the board, the chair and others, Mr. Smith, some of which you've taken to, not all of them. How do you judge or how relevant do you think those views are for this inspector to take into account, and what weight would you invite him to give them when he's considering matters they address this appeal?
I would certainly give those great weight. The comments have come from both the planning advisor, Mr. Smith, Mr. Clive Smith. Mr. Clive Smith is not only the National Landscapes Planning Advisor, but also the former head of planning at Mole Valley. So many years experience as a town planner. And then you also obviously have Catherine Atkinson, who's the chair
Yes.
of the Surrey Hills National Landscape Board. And of course, the board, as we know, are the authors of the management plan and also the environmental design guidance as well.
Yes. Could you just take up the chair's response? That's NID 2.2. Please, could you ask some questions about that one, as I recall, and some general points put you the board, particularly the chair, hadn't really turned her mind to the particulars and the policies, B1 and B2. Could I actually ask you to look at page 2, which is also PDF 2 of that representation to the inspector? There's 3 paragraphs up from the bottom. There's a paragraph beginning, the fact that the Surrey Hills. Do you see that?
Yes, thank you.
Sir, do you have that, sir? Thank you. So that paragraph, it talks about being a statutory plan, therefore material planning consideration, its preparations be through the necessary statutory procedures. The plan has been formally adopted by all the planning authorities. The appeal proposed is directly contrary to the thrust of the plan, read as a whole, and more specifically, planning policies P1 and P2. So to what extent do you consider it's fair to say they haven't turned their mind to the policies or not?
To what extent have do you
think they have turned their minds to P1 and P2 or not?
Oh, no, certainly they have, yes. Excuse me. Yeah.
Thank you. Now, you were asked some questions about scouts.
Yes.
And you gave answers that an issue between you and the appellants. You didn't think there was a need. Just looking at all the evidence you've seen before this inquiry, in light of that evidence, what's your judgment as to whether the inspector should conclude that there's a need for a new scout facility or not?
Well, in terms of is there a need, they have their existing premises. There's been a long ongoing conversation with the scouts. There's a draft lease that's been exchanged between them and the authority. It's not as though they're in a position where they're about to be evicted. So in terms of the need for alternative premises, I don't believe there is a need. I think they have a draft lease, and as part of one of those clauses, it's a peppercorn rent clause. But for whatever reason, I'm not sure what that reason is, that lease has not yet been renewed.
Okay. Thank you. Now, core document 7.40, which is the land availability assessment from November 2020. You were asked some questions about that, and there was some suggestion, I think, and this may just be a point of fact we can deal with if you can't help me now, that the assessment that you'd referred to for the appeal site included phase 1, the phase 1 site. Can I just ask you to look at, if you have that document, could you go to PDF page 269, please? And if there's a dispute over that, there's there, you tell me if I'm wrong, PDF 269, there's reference to a site. Will you tell me what site we've got there? I think if I'm looking at the right correct page, PDF 269 site 1124.
Yes, I have that. Thank you.
And if you scroll down to the next page, this is the Red Court, Scotland Lane. There's a little area identifying what that particular site assessment addressed is. What area is that, as you understand it?
That is the phase 1 site. Not part of the appeal site.
Yeah, I think we were indicating now the appeal site was 98987 elsewhere. All right, thank you. Now, core document 6.1, part 1, LPP1. If you could turn that up, please.
Yes.
Wherever you have it. And you asked some questions, particularly about the context or the approach to RE 3, so if you go to RE3, which is, I think, it's PDF page 64,
Yes, thank you.
and you remember you had a series of questions. Wait, let me get there. Yeah, there were some questions put to you about to what extent there was any difference in approach between Roman numerals 1 and 2, one dealing with the what's now the national landscape, 2 with areas of great landscape value, which of course is what phase 1 was in. And it was said to you, well, there's the phrase, the same principles for protecting the AONB will apply to the area of great landscape value. And you said, well, I think my note is you said, well, you relied on the phrase at the end, commensurate with the status of local landscape, to say there's a difference in weight to be applied to them. That
Yes,
was
that's
a debate
right.
you had.
Yes.
Now, you weren't taken to this bit. Can I just ask you to look at the text to assist us to construe this policy? If you go to PDF, a couple of pages before in this local plan, the text proceeds. If you can look at para 13.35, so a couple of pages before, I think it's on PDF 62. There's a paragraph 13 that says beginning therefore until the AONB review. Do you have that?
Yes, I do. Thank you.
And about halfway down, it's talking about the role AGLV and the role it plays as a buffer to the OMB. However, as a local designation, the AGLV holds less weight than the AONB in policy terms. Does that assist your position, do you think, or not?
Yeah, no, certainly. That's very much in line with my opinion.
I noticed when I was looking at this, we're actually missing page 122 in the electronic copy before. I don't think there's anything sinister there, but if you want page 122, so we can get you a copy of that, which is the preceding part of this section on the AONB. Now, thank you. Could we, yes, back to the NPPF. You asked some questions about 190 and the contextual approach to it. And it was said to you, well, that hasn't changed in its wording, putting aside paragraph numbers for almost ever. It's always been the same way in relation to what are now called national landscapes. And you quite properly agree with that. To what extent do you think, particularly in the latest version that's been available for the last few weeks and months, the context relevant to 190's changed in terms of national considerations one finds in the NPPF to start with? To what extent do you think it's changed or not?
I think the government's emphasis has changed. We know the government are committed to addressing the housing crisis, but we also know the government are fully committed to protecting the national landscapes and giving the national landscapes the very highest priorities. We know that the government have, in terms of trying to achieve their aims of addressing the housing crisis, they've looked at certain other aspects of the NPPF. They've looked at previously developed land, they've looked at Greenbelt, they're looking at those areas are locations to help resolve that issue. What they haven't done is in any way weakened or diluted the approach in the NPPF towards national landscapes.
Yeah.
And obviously through the LURA and the amendments that gives to the Crow Act as well. I'd suggest they're actually strengthening their approach now to the national landscape.
Yeah, okay. And because various points were put to you in terms of when you look at 190A and the phrase the need for development, including in terms of any national considerations, the various points were put to you, well, national considerations, well, that will include the new standard method, the 5-year supply, the need for 1.5 million homes. Some of the factors you've just mentioned, grey belt, brownfield land, PPG references and so forth, to what extent do you consider they would also be national considerations that the inspector would want to bear in mind?
Very much so, yes.
And that which may be part of the difference, the heart of this appeal, perhaps, this distinction between the new level of identified need to the standard method for Waverley and other authorities, and against that, what you've described to the inspector as also changing consideration in terms of protection for national landscape. To what extent do you think those two aspects of national policy can be detached from each other in this kind of case, or do you think they have to be considered together?
There's a balance there to be struck, of course. Yes.
Good. Thank you. Yeah. Now you were taken in the context of a number of things, the approach to alternatives to the Wielden case, which I think we have at two places. I think we have at CD 10.7 and CD 10.1. I think both of them are the Court of Appeal, slightly different version reports. But if I don't mind which one you go to, but say whichever one you'd like to go to, 10.7 or 10.1, just tell me which one you're looking at.
10.7.
10.7, okay. So this is the Court of Appeal judgment. You were taking the first bit. I just want to take you to para 63 of the judgment, because you were taken to some of the particular facts in underlying that case and the approach taken by the inspector, which the court said was a lawful way of doing it. Paragraph 63, it's getting there, which is PDF page 18 or 17, actually the bottom of 17 going over to 18.
Yes, thank you.
The court says, and the policy it's referring to, the exceptional circumstance, what's now 190, the policy requires the exercise of planning judgment. The decision maker must consider whether there are exceptional circumstances. Then it refers to the 3 bullet points. I won't read it all out, inspector will see it, and says what's required. And at the end, you'll say, last 3 lines, it doesn't say this exercise must relate to the whole of a planning area or to an area larger or smaller than that. This will always depend on the circumstance of the case in the hand. So to what extent do you understand, some of this is a matter of law rather than policy, but in your judgment approach, is there only one way that a decision maker can or is required to approach 190 when asking him or herself whether there are exceptional circumstances, or is it a broad matter of planning judgment as your understanding of it?
It's very much a broad judgment. I think that's been a continuing theme of my evidence. And there's you do have A, B, and C, but there's nothing to preclude a wider assessment than those A, B, and C, which is just referred to as things to be included in an assessment.
Yeah, and you were taken to various versions of what then existed in Paras 49 and 49 of the NPPF about need for boosting housing and so forth. Did the sort of considerations you referred to about Greybelt and some of the amendments to Brownfield land and so forth, did they exist at the time of the Wielden inspector's consideration of matters?
No.
Just while we've got, so we don't have to go back to it. Yeah, I mean, as you put to you that, well, the inspector in Wielden took the approach that Mr. Marici, or more accurately, Mr. Collins is taking. But in policy terms, so far as you understand it, do you have to do it? Is it being suggested to you, or do you think it's the position that one has to do it in the way the appellants said you're doing it, or is it a matter of judgment?
No, not at all. It's a matter of judgment. Yes.
And you were asked, well, the appellants chosen at this appeal to produce lots of appeal cases. You haven't taken a similar approach. Do you think, given that if that's the correct position in law and policy, you think one is required to produce appeal cases to demonstrate that you can do it another way?
No, I think.
I mean, if we need one, the previous inspector, NID 3.8, did he take the approach that the appellants, I think, suggested he take at the last inquiry as they do here?
Yes, so the question is, sorry.
Did the previous inspector follow the approach they're suggesting? The appellants
I see. No.
As you understand it, and maybe it's Mr. Law, any of the challenges in the High Court relating to him being incorrect in the approach he took as to alternatives?
No.
Okay, right. Now, you were asked a number of questions about various other cases, appeal decisions. I'm not going to traverse all with you, and I'll obviously be asking Mr. Collins about some of them so far as the inspector's patience holds out. But can we just look, for example, in the Sonning case, if you take up the previous inspector's decision at NID 3.8, please, because I think these arguments were run before him as well. can you look in the previous inspector's decision at paragraph 173, please? And you'll see in relation to the Sonning case, he said he acknowledges there's some comparability in terms of the representativeness of a given element of an A and B to its characteristics as a whole. There, the inspector nevertheless set out, and then he quotes from the inspector in relation to the particular findings on that in that case. Again, is that a point you think is a good one to distinguish it, or do you think it's not a good one?
Yes, well, the quotation is there. I do not consider the appeal site or its local landscape context to be representative of the special qualities as set out in the Chilterns AONB management plan.
In relation to stay with this, it's probably a convenient way to traverse some of the matters. And in the para 170, the inspector addressed at the last inquiries, this inspector's asked to address here the Great Missenden case. And you'll see two paragraphs here really. 169 actually is when the inspector starts on it. He said he accepts the inspector determined that the appeal site made, quote, no material contribution to the AONB and longer views. In this instance, visibility of the appeal site is relatively localised. However, the inspector there also identified the site had already been indicatively identified in the draft housing and economic land availability assessment as being appropriate in principle for accommodating housing.
Yeah.
That's not the case here, he says.
No.
And again, do you think that's a distinguishing characteristic in your judgment?
Yes.
And then he goes on, furthermore, the inspector says at 170, the scheme of Great Missenden was for development of 34 dwellings, far smaller than the proposal here. It also entailed the demolition of 3 to 4 bed houses, a disused industrial building, and 20 garages. Again, compare that to the existing situation on our appeal site. Do you think these are similar cases that should be troubling this inspector?
No, clearly very, very different.
All right. Okay. Now, in relation to the Oakley case, you also just look at 175.
Yes.
Where this last inspector dealt with, accepted there'll be some harm. However, in that particular case, it explained the site is very unusual in that it is bounded by residential development on 3.5 sides and the remaining 4 sides an engineered landscape. Again, so far as the inspector's got documents relating to that, is that going to assist this inspector in relation to this scheme?
No, not at all.
Now, in relation, you asked about the Turndon case. I mean, I don't want to go back over it too much. NID 7, but we perhaps don't even need to turn it up, but we can if we like. But one of the points you kept making to my learned friend was, well, in that site, particularly at the Secretary of State stage, there was an emerging allocation which had reached quite a late stage. So very references. Now, in your judgment, to what extent did that factual position, as you read the Secretary of State's decision for the moment, inform her conclusion as to exceptional circumstances?
It must have been one of the key drivers.
Yeah.
Not only a draft allocation, and I think the Secretary of State gave that significant weight. And the only reason it wasn't given full weight, because it wasn't adopted, but it was pretty much adopted because it was very close to adoption and there were no proposed modifications. So it's pretty likely that was going to be adopted in due course.
Yeah. All right. Well, I'll save all questions for Mr. Collins next week, because I think looked at that a lot today. And the Sturt Farm, you were asked some questions about. You remember we looked at the officer report and CD 11.5, and again, we perhaps don't need to go there. That was a case, as I recall, for about 10 years ago, 2015. I may be wrong, but thereabouts. So just to give us some context, at that stage, did we have the current version of the NPPF with all the new context you described? No. Did we have some of the PPG references you're relying on?
No, I don't believe so. No.
Did we have the statutory duty in its current form?
No, we didn't.
No. Did we have the management plan? It was 2019, the management plan in its current form.
No, not in its current form.
Okay. All right. So there's that. Now, there was some discussion about access, and it was put to you, well, actually, with assignment permission, there was actually a lot of engineering work done in relation to the access. So far as your examination of the documents, and we've got the officer's report, if you consider the access for this proposed scheme includes, as part of the way to get to the site, the road going up the LCA 1 bottom western bit, how comparable, so far as you can tell, do you think it is in terms of built development or built structures and engineering works?
It's very, very different. The proposed point of access into the appeal site, there is no access there at the moment. In fact, there's a line of, as we've been talking about, a line of mature trees.
Yeah.
Very rural context as well.
Yeah.
Stretch of Midhurst
Right.
Road. So very, very different, I'd suggest, to Sturt Farm.
Yeah. Now, in the Turnlin case and some of the other cases you were taken to, the situation, Turnlin, let's take this example, there'd been an emerging local plan process, as you explained to the inspector, and this is evident, with lots of considerations of alternatives leading to some draft allocations at the end of that process.
Yes.
And that, as you've said, in your view, informed acceptance. Now, in our case, I mean, how long ago did the grey belt, we know that the NPPF was December. I think there's been quite detailed PPG guidance on grey belts in the last few weeks, maybe a couple of months ago.
Yes.
One loses track of time in planning these days.
Yes.
And now, that's the context of, that's what the government have said, and you've said to the inspector, this council's now getting on and got a new timetable to take those and other matters into account. It was put to you, well, there's no Greenbelt study taking into those matters published by the local authority. I mean, to what extent is that, in your view, surprising or to be expected at this stage?
It's yes. Well, as you say, it's not been that long since we've had the latest draft of the NPPF, and even shorter time since we've had the guidance in the PPG on Greenbelt, Greybelt.
And so, in that sort of 7 to 12% of land that's not, it's in the Greenbelt, but not in other designations that Mr. Collins speak to you. A few weeks ago, we've got the new guidance. What's your assessment of potential for there being some sites within there, given that amount of land?
I think it's highly, there is a strong chance there'll be a number of sites within that 12%. I'm not entirely sure what that area comprises, but it's going to be a fairly large area.
I mean, especially in relation to the recent guidance on how you assess what Greybelt land is in PPG. I mean, has the appellant, as far as you're aware, produced any evidence to show that there won't be any Greybelt sites?
No, not at all.
Thank you. Now, last couple of questions, I think. I'll do that one. No, happily, I've covered all those. I can deal with those ones. So those are my questions. Thank you very much, sir. Thank you, Mr. Johnson.
Thank you.
Thanks very much, both.
Thank you.
Okay. Let's just pick up then on a few housekeeping matters. First of all, let's have a look at next week. We're moving straight on, first of all, to the examination in chief of Mr. Collins. Last I heard, a couple of hours.
Yeah, a couple of hours. I mean, it might go a little bit over, but that's it.
Okay. So that's, let's call that Wednesday morning. Cross-examination of Mr. Collins. Again, last I heard, a combination of Mr. Cosgrove and Mr. Brown, 3.5 hours.
I may tip over 3 into 3.5, but I hope not to go beyond that.
I mean, it sounds to me, and I mean, please tell me if I'm wrong, that there was discussion about the evidence running over into the Thursday.
Might not happen.
Well, I hope it doesn't, because I'm running into difficulties.
Well, if we can avoid it happening, and I don't know so whether we can sit a little bit later on Wednesday if we need to. I know we don't want to sit for hours, but
Yeah.
if we had to sit, half an hour, 45 minutes after 5 to get it finished,
Yeah.
then that would work. And we could also start earlier if everyone was happy with that. 9 o'clock.
I'm happy to start a bit earlier, but I'm not staying the night. I'm happy to start at 9, but beyond that, I
Yes.
didn't want an 8 o'clock start.
No, I'm not.
Well, you
6 a.m.
never know with you, Mr. I've got to drive here that morning, but that's fine. I'm happy to start a bit earlier. I mean, I'll look. I think Big Brother's listening, so we'll know about whether we can stay that night. I don't know the answer
Yeah.
immediately.
Well, let's leave the 9:30 start. But certainly if it helps, I can run on a bit, certainly into into the very early evening.
Yeah, so I think when we were contemplating Thursday definitely happening, it was if I'd gone significantly past lunchtime today, which I haven't done,
Yeah.
and the time estimates are now such that we probably could, although it might be a slightly long day, do it in a day. And clearly if we could, it's
Yeah.
much better that we do.
It's better all round. I mean, I'll work on the assumption that it's one day. If it turns out not to be, I haven't had to cut anybody down in terms of time, nor do I want to. If it turns out not to be, then we will run on to the Thursday. As I say, that does give problems to the site visit. We'll cross that bridge if we need to do so. So the site visit will be on Thursday, hopefully, and we've got a date, 6th of May, I recall, for the closing submissions. So that is all fine in terms of the programme for next week. Just running through my note of outstanding matters. Conditions, I think, are still being discussed. There's been various references to discussion on conditions, but I'm also conscious, obviously, that you haven't been able to be involved in those discussions for the moment. But I mean, that's still active, I take it.
It is active, sir, but it will be a fairly short-lived process to get those agreed, I think, so.
Yeah, I
So-
certainly got the impression we were very close on that.
Yes.
Okay. 106 issues and an explanatory document and indeed SIL compliance statement. Heard a lot about the draft 106, but I haven't seen anything.
I could give a bit of an update there, sir,
Yeah.
if I may. We received the appellant's updates to section 106 at the start of the week. The borough solicitor has reviewed those. I believe that's now at a point where just need to sign off. Now, borough solicitor's on leave until Tuesday. So my understanding is Tuesday will be the day when it goes back to, there's been some late changes from the appellant. So it'll go back to the appellant on Tuesday. I have shared an email this morning with the appellant, just giving this bit of an update as well, and also an update on the SIL compliance statement as well,
Yep.
which I've provided a draft, copied to the Rule 6 party as well, but that is in draft. So given that we've got a bit of movement on the 106,
Okay.
but that's in draft and fairly well progressed now.
That
too.
sounds good. And there was a mention of an explanatory document.
Yeah, so that was from us, but I think Mr. Cosgrove asked me sensibly to wait until we knew exactly whether we were agreed on the 106 before we put in a statement to explain what it does. So I think when we get it back from the council, depending on where we are, I mean, we've got a draft of it. It's ready to go, but subject to where we get to on the point that's.
I think it would be quite helpful.
Yes.
And
And so the related point is, when will we deal with the 106? And the conditions.
I wish you hadn't asked that.
Yes. Well, so I mean, there is a possibility, of course, that we could deal with it virtually on the morning that we close, because I don't think it's going to take a very long time, is it? I mean, it's not ideal that, but or we could set up another date between.
Yes. Sorry, I mean, I agree with that. I mean, the only thing is I haven't been, I'm afraid, involved yet. I'm waiting for the document to prepare. But is there any issue on that? I mean, you don't know until, I think you mentioned something about the transport contributions. If there was going to be an issue, and there may well be, the county, I think, deal with that, might need to be here. They certainly want to understand them and speak to it. And I just wonder if that might be a reason to putting it off to the 6th of May so we can timetable them in for a.
Yes.
I mean, the conditions, I suspect, will take about 5 minutes, if that. 106 will take a bit longer to talk me through it. I mean, I suppose in an ideal world, do it Tuesday afternoon late, but if we're already looking at a tight day, I'd be quite happy to do that virtually on the 6th.
Yes.
Either on the 6th or I mean, not necessarily a session that council have to attend. I don't know what you feel about that, but we could find another hour or two to do a virtual session between next Tuesday and the 6th.
Everyone keeps saying it's Tuesday, it's next Wednesday.
So it's Wednesday.
Give me
Yes,
slightly
Wednesday.
panicked. We're not sitting next
Wednesday we're
Tuesday.
sitting. Next Wednesday we're sitting.
Before you get a train from Yorkshire to see
Yes.
where is everyone?
Yes, I mean, so on the contribution towards transport, there's a contribution towards DRT, isn't it? It's called demand response transport, these small buses. We've agreed to pay the contribution in the 106 with the county, but there's obviously a usual blue pencil clause, and we don't accept that it has been demonstrated that that's necessary. If you deem it is, then obviously it gets paid. So there is that issue to discuss. Mr. Cosgrove is right, there will be that issue to discuss.
I mean, obviously, I'm not the county, but we want to make sure they know that, and that can be related, so they can put something in or attend to speak to that point to explain their position.
It sounds as though, from their point of view, that might be a bit tight on, get it right, Wednesday. Because obviously it's still moving around between the parties.
Well, let's just do it on the 6th, shall we? I mean, maybe that's the best thing. I
Yeah,
don't
why
know.
don't we just do it on the
I
6th?
would be, and in a way, with the Teams link, it probably makes it easier for the relevant officer to tune in
Yeah,
in terms of their timing. Not that that's a
I think.
consideration, but
yeah.
they've obviously they've
I think
got-
so. If the county can turn up on the
Yeah.
6th, we'll deal with that first.
Okay.
Conditions, frankly, I suspect we can probably deal with last thing on Wednesday, but yeah. Okay, other matters. Anything, I've not seen anything from the Scouts in relation to the Scout hut position. We obviously heard evidence just today on that. I did actually originally give them a deadline of the end of today. They wanted to come back on anything on that. I mean, the reason I did that was that I wanted to get it done by the time we'd finished evidence. Well, we're not finishing evidence till, get the date right, next Wednesday. I mean, if the Scouts come back before the end of Wednesday, I'm not going to invite them to do so, but if they come back before the end of Wednesday with anything, then I'll accept that because we're still in evidence at that point. But I mean, we've heard evidence on that. There may be something to come from the Scouts and doubtless from Mr. Collins.
Yes, Mr. Collins will deal with it.
So
from our side.
the Scouts themselves, it's in their court, basically.
That's absolutely fine. So far as I mean, I'll obviously reserve my position in case something came in that was new that we wanted to respond to. But
Oh,
absolutely
yeah.
subject to that. Fine.
Yeah, okay. Then a couple of other matters. Ecological timeline. There was the document that the Rule 6 party put in on this, and I think there was going to be a discussion between the Rule 6 party and the appellant to come up with an agreed ecological
Yeah, we'll need
timeline.
to chase up Mr. Jack, who's not
Yeah, sure.
here, but that
Okay.
is something I'm sure we can do because I don't think there was a huge amount between us in terms of
Yeah.
that chronology.
That's fine. Now, I've also made a note, statement of common ground on ecology, Rule 6 and appellant.
I think we gave you a final copy of that.
Yes, that's why I'm sounding slightly hesitant. I think I've got the final copy.
You've got the final version, and I think it may have even gone up on the. Just checking. I think it may have gone up. on the-
Yes, I'm pretty sure I've
Yeah.
got it.
Yeah, so
Sorry,
that's done.
So I think the confusion was that you'd had the emailed version which said draft on it.
That's it,
In
yes.
fact, that was the final
That was-
version. It
that
just
was it.
the
It was
name
the-
of the file
Yeah,
had not been
It was
changed.
that terminology, that's what threw me. And then, last but not least, the landscape and visual agreed tables as between council and the
Yes.
appellant.
So without kind of getting into he said, she said, it's proving quite difficult. And I think my strong preference, and I have briefly discussed this with Mr. Cosgrove, is that we record what we say the position is from the evidence in our closings. I know it would have been ideal to have an agreed position, but so it's taking up quite a lot of time and it's not really moving anywhere. So I know you've asked for it and we would like to provide it, but it is proving a bit of a time-consuming exercise and not really going anywhere. So if you were happy, I would strongly urge that we move back to simply recording, and I will do it fully in our closing, what we say the positions are. And obviously you have your own notes, but we will record the position very fully.
I quite understand. I mean, that sort of thing sounds great in theory, but when you actually come to try to do it, I can appreciate that it becomes more cumbersome. I'm fine with that. That can go into the closings on from both parties. And yeah, I mean, if you can make it very clear in your closings exactly what your position is on the various elements, table form, whatever, but not scattered throughout the closing.
No,
That's
so
what I'm getting at.
we will do it as a table, probably
Yeah.
in an annex, I think. So yeah.
Yeah, fine. Those are all my notes, unless there's anything further. Yes.
So, may I just ask a question about the Thursday site visit? I think it's Thursday,
It is.
the site visit. Unfortunately, I have another commitment. It's a hearing, so I have to attend that on the Thursday. Now, would you be happy with an officer from the council attending on my behalf, or one of my colleagues from my practice? As it's given, it's a factual exercise, isn't it? So-
Yeah, totally factual exercise. Yeah, completely happy with that. Obviously,
Thank you.
whoever, as you know, no discussion obviously of the merits of the case.
Yes.
But provided they're briefed on the case so that if I say, oh, well, I don't know, where would the sang be? Everybody can point to where the sang would be, but yeah, completely understood.
Thanks.
Enjoy-
If it's
enjoy
something I could
hearing.
move, I would move it, but it's one of those
No,
movable
no.
things. So
I don't want to offend
Thank you.
another inspector.
thank you.
No, that's absolutely understood.
Thank you.
If you could let me have the name of the person attending. Just sticking on that, assuming we can get the site visit in on the Thursday. Sorry, just thinking out loud. I think my preference would be to do the accompanied visit on the site first. So we can talk about it next week, but sort of 10 o'clock in the morning on site for the three parties. And then you can leave me to go around the area, well, lunchtime onwards.
So that's fine. I think if it's Thursday, it'll be Mr. Andrew Smith. You only want one person, don't you? From each
For
sort of-
preference, yes.
Yes. So it'll be Mr. Andrew Smith from our side.
Yep.
I don't know who's coming. It will be
Okay.
okay. And so the other thing is, I think that we will. There's been obviously discussion about Sturt Farm,
Yes.
which we would like you to go and see, which you can do on your own. The one thing is so that we would like you just to see when you go there where the access was proposed as the officers considered it in the report. Now, I think we can do that by marking it on a plan, I guess. That'll probably be the easiest way.
Yeah.
Yeah. Okay. That's
And I
fine.
mean, yeah, absolutely.
Or,
yeah,
or show,
I mean-
or we could print out a Google Earth picture of where it is and just show it, give it to
Yeah.
you.
I mean, Sturt Farm's on my list to visit anyway, but yeah, given the discussion about it was approved there, but actually it's somewhere else, that would be helpful, yeah.
So just going to ask one other question, which is it possible, I know you only really wanted one person, but Mr. Smith is obviously going to be there to point things out to you. Is it possible to have someone there from our side, on the agent side, to actually let us through and to go around the site with us? Obviously, they're not going to say anything, but just for
Yeah.
access.
Yeah, absolutely.
And everything else.
I mean, not in this particular case, but I'm a bit allergic to site visits where you end up with a whole troop of people going
Yeah.
around the place. But yeah, no, that's absolutely
Okay,
fine.
thank you.
Yeah. Okay, I think we're there then. Right, thanks all very much for this week, and I'll see you, get this right, I'll see you at 9:30 next Wednesday. Right, thanks very much. Enjoy the break.